baseline estate planning guidance, and I'm going to touch upon some of the issues. Again, I'm not a tax practitioner or an elder law, and much of this is focused on how to get you started and what to do. I'm an attorney. I went to an estate attorney for my will. It's one of the top 4, usually it's 3 or 4 areas of malpractice. If you're in a high net worth estate, certainly you have significant tax considerations. You have what I thought the value was, certain considerations just when you have 2 kids. You know, there's a division. So you really should go to someone who's appropriately trained for this. And what I'm going to get into is choosing your attorney. And where do you start out? I like to tell people, radiate out. Start with your family, people you trust, maybe your own attorney. And if you have personal attorney, ask them. They may not have the expertise, but they can send you to someone who has this. Who do they use? You know, the same thing you do with your doctors. You ask them for referrals. But also your business associates. You in the farm community know who helps other farmers. And maybe those that you hold in high esteem and respect, and you think you would act similarly, ask them. Then you can look to your own professionals. I said, there's also the bar associations keep a listing, and they have them broken down into categories. These are self-reported, so it's just who wants people to think that they do this work. There's professional organizations, and I'll go over a bunch of them, but what you want to look for is the criteria to gain acceptance to the professional organization. And is it third-party validated? Is it educational? Is it experience? You want to know what's the worth of the credential. 2 educational designations that are very valuable are the LLM and the estate planning certification. And it's a separate, after your JD, you would go on for further, usually it's 2 years, and it's mostly tax, and it's generally set up as a 2-year curriculum. One is tax, and the other year is more general estate planning and estate issues. Some of the the law schools now offer estate planning certification. It's sort of half of an LLM, and it's basically just doing the estate planning without all the sundry tax courses. Sometimes you look and people already have a CPA. You know, maybe they just want to be an estate planning certification candidate. They already have that. Specialty designations, and for attorneys, the National Association of Elder Law Attorneys, they have a certified elder law designation. It's called CELA. And it is pretty rigorous. They will actually come and review files. They'll have to have recommendations from other practitioners. There's tests that they have to sit for days. There's educational components. So those are the types of things that have value. There's also the American College of Trust and Estates Council, and you're nominated. And this seems to me to be the creme de la creme. You may not need this. You may be, there's some things about attorneys, you don't always need a big attorney from a big law firm. And I've been in big law firms. I'm on my own. Attorneys choose to practice in the way they practice. But sometimes, you go to a specialty attorney, that's all they do. They may want to work with other attorneys. Hence, I've worked with estate attorneys. But when you're in a bigger firm, generally it's all under the umbrella and it's all in-house. That's a difference. There are some multidisciplinary accreditations that you'll see other types of professionals carry, and I go through some of those on the bottom. Just make sure that if someone's touting an accreditation, that you know what it is and you know what it stands for. Certified financial planner, some of them that you would know more about, but there are certain designations that really I think attorneys look at, so that if I were referring a matter, I would only refer it to an LLM, if it was a certain type of matter. I just do that to protect my own reputation, and I think your professionals will do the same. When you go to your first meeting with your attorney, a lot of times attorneys will have a paralegal talk to you beforehand. They may send you out a letter with what you're to bring. And I know that Bob and Barbara talked about some of these things. They want to know what you have. They want to know everything, how it's titled, what are your, any life insurance. They also want to know your safety deposit boxes. They want to know where things might be located, your business documents, whatever your contractual assets are. You may have, you may have loaned someone some money. You have a note for someone. You want to disclose that, as well as if you have an option to purchase something, any other type of asset. The proprietary questionnaires usually look at a lot of personal information. I've seen a number of these, and it's because they want to know what they have to deal with in terms of other family members, in terms of what's out there, so that they can question you and they can probe into areas and it's a thought-provoking process to actually go through this, and you'll probably find you'll have no answer when they first discuss things with you, and you have to really mull through and think it over. But you won't get into that dialogue unless you reveal things. For example, you may have one natural heir that you really do want to disinherit. It's sad to say, but you may, and you want to address that with your attorney. The reasons, how you'll make it, so that there's no problem with any challenge. And some of those things you're better served for disclosing a lot, airing your dirty laundry. It's all private. And it'll help them better address what are your concerns. If you have, the possibility that someone may need lifelong care and special needs, second marriages, these are all different circumstances that need to be addressed, whether or not the son-in-law is doing the better job at running the business than the son. And again, some of those types of matters have been alluded to, but your attorney should review all this. At this point, I have a generic statement of what is estate planning, but you're going to look at what are your financial needs and how are you going to achieve those goals and what are you going to do. And there's a whole bevy of programs and things that you may want to look at. There was Medicaid planning that was alluded to, which is depleting your assets, and it's all based on the personal circumstances. That may be the best alternatives based on your needs, your assets, and what is set up, but no one will be able, you can't address this in a generic format. You need to address it individually with your circumstance. And you're not looking at it in a vacuum. You're looking at risk. You're looking at how is the business going to be run? How are things, you have to disaster plan. And you're really looking at taking care of things as best you can. As Barbara said, you can't control everything, but what you can control, that's what you're trying to do. You're trying to achieve your goals and really manage your risks of something bad happening. When you meet with your attorney, you may want to bring other people with you. You may want to bring, and I'm a proponent of an assembled team, and it's something that could help you if your CPA comes in. Usually your CPA, you have a long-standing, my dad was a CPA, and at his funeral, all of his clients from when he was 20 were still there. You may want to bring them. You generally trust your CPA, your accountant, I should say, and you may want to have them as part of your team or anyone else. Know that if other people are in the room and you're the client, anything that's said is not attorney-client privilege because you've let a third person into the room. Just to be wary of that, if down the road anything should happen, the other side can, question the third party, what was said, But a lot of times families will go in, and an attorney generally should say to a group that's assembled there, who are potentially have an interest in the matter. I'm not talking about a professional brought in to help or a friend, an advisor, but someone who potentially could have an interest in the matter. The attorney has to represent a client, and they can represent diverse clients with diverse interests only if everyone agrees, and there's a consent and waiver, and there's mutuality. Families often do go in together and everyone discloses certain things, and then oftentimes an attorney will say, well, I'm representing mom and dad and I meet with them separately. And it shouldn't be offensive. It's part of our ethics and it's how we agree to do things unless the client agrees to bring in other individuals or there's that consent. There should not be disclosure to anyone other than the client. Generally, attorneys will, and they will meet with you for a consultation. Some will charge a couple $100s, and they'll give you a substantial amount of time because they really want it. It's a getting to know one another, getting to understand what the issues are, because you really don't know when someone is just calling you up saying, I need a will, how complex it is. Or maybe they say, I need a will, but they really need something else, and that's what you're going to recommend. But many times they will meet with you for a couple hours, charge you maybe $300, and I think it's a valuable exercise even just to get you started. And maybe you don't retain them. Maybe it was just something to get you started in a different direction. Sometimes they won't. Sometimes they'll say, I need to be retained. I'm not giving away my time. It's just, that's a personal preference. That's a marketplace issue. Many attorneys will go to remote locations, especially with elder populations. They will also make it so that it's convenient. There's often travel restrictions, and it's certainly to make it convenient. Most attorneys will want a face-to-face. A lot of times when some of these issues are being discussed and it's an elder person, there's a question of whether or not the person has capacity or is vulnerable. They will want, it's not unheard of to have videotapes of some of the meetings to make sure that there's no problem down the road with a challenge. But these are sometimes the attorneys, if they ask the question about your health, they want to know that you don't have dementia or anything that could impair your cognitive abilities. Sometimes if they do have any perception of that, they may say, I'd like a doctor's note to say that you're capable of it. And they turn you away because they don't want to get involved. So these are all things, but generally attorneys will go to meet a client, and they'll do it out of convenience and courtesy generally. And it makes sense. It's easier now that technology is so mobile. I've brought printers out to execute wills at people's homes. You usually have your discussions of everything you want to do and what are the vehicles for doing it, and I've named a couple of the different types of trusts. Trusts are oftentimes used. You may have discussions of lifetime gifting, which again has to do with more Medicaid planning or tax ramifications. But what the attorney's role, I believe, is to discuss with you all the worst case scenarios so that you have an idea what you're trying to plan against. And you may not know of these things until you're educated by your attorney. And some of them are listed here, but I do want to say that you can't control everything, as Barbara said, but again, you're managing your risk so that you can have things proceed either in your lifetime or in the next generation's lifetime with any transfer, the goal and the decision that you want to implement. When you have an estate, I'm giving you a couple of the functionaries, and these may be people who are in charge of an estate. You have the executor, executress. This is what they do. They get everything together, they identify claims, and then they distribute the assets and they pay off the liabilities. And when you're picking someone, you really should look at the functions that they're doing. Who's the best person to handle this? It may not be your spouse. It may not be someone from a geographic standpoint, you're the only sibling or someone who you would normally think would be the most appropriate person. But looking at that, and always have a successor or alternate in case they decline. A trustee is a manager, and so they're a fiduciary to the beneficiaries of the trust. They're working on their behalf, and they have certain obligations. A lot of times trustees are professionals. Trustees generally have insurance, and certainly they're treated as that. They may be paid, they may not be, depending, and again, this is the way you set up your agreement and your appointments. It's all personal driven, and it's what you choose to do. If there's a guardian, there's always going to be a guardian if there's a minor or if there's an incapacitated person after the age of majority who has been declared incapacitated by the court, and that's a process. They make all the decisions, so you can't have anyone who is incapacitated in the formal sense make any legal determinations, so that even if that person is a beneficiary, the guardian may decline the benefits for reasons that have nothing to do with not wanting the money, but to keep other governmental benefits. You can have additional layers of protection. You can have another fiduciary who's a trust protector, so like sort of the super trustee that oversees the trustee if you have any doubts or you just want another set of eyes. But the more people that you have reviewing things, the more problems you can have too. You know, it's a layer of protection, but it's also a layer of complexity. But there are valid situations and circumstances where it may be warranted. A lot of times the trustee could be the sole surviving parent, but maybe there's concern about their judgment, so you have a super trust. It makes sense that the trustee is the parent who's of their guardian, that they would have the right to make determinations, but you have someone overseeing. Always have contingent functionaries. The probate process, and Bob said, California's more complex than Vermont. New Jersey's, it's not complex, but it's time-consuming, and it's expensive. I don't think it's complex, but other people may have different views. But you generally, it's with the surrogate of the county of residence. You go with the death certificate 10 days after death, and you get letters testamentary issued, and then the executor or executrix would open up an account because they have to do everything by the estate. You can file that there's no probate if it's less than $10,000 in the assets of the estate. You have to then give notice to everyone that's an heir, a spouse, or any beneficiaries of the will that you have, giving them certain opportunities to then potentially challenge that it's not a valid will or there's a problem. Then there's the more general functions, administrative functions, which is marshaling the assets, taking your inventory. And this can be problematic if people haven't done the inventory that Barbara talked about and you don't know where things are. Things are missed. You don't, believe me, people will come around where they want something from you, but if you don't identify on a life insurance policy that you have it and it's hidden someplace, no one knows to file for the benefits. So then you're also settling the debts, and you might have to sell assets, or you may have to get appraisals of assets, and that may be for estate tax purposes. You do your filings, and that's generally done with the help of a state counsel. And the last thing is distribution to the beneficiaries, and that could be a year's process. Will contests and probate challenges are the #1 issues, and you're going to see those. The more individuals with interests and the less everyone's worked together, I think that's when these crop up more. They're looking at challenging the document itself, and that may be the authenticity. It's not the person's signature, or it's not valid. It wasn't executed in the proper manner. There's an execution requirement in New Jersey. There's a time parameter to do this, and it may be that the will that's presented, they're saying that's not the last one, there's another one. So they have a time period built into the process to let someone come forward with another document. They may say that while this is the last one, the person had diminished capacity, even if not full incapacity, and maybe was coerced into doing this by someone who had the opportunity to exert undue influence. Those are the types of challenges. What they might have to do is show what they're doing in terms of the probate, that it's all at least accurate. There may be a expectation that a house is worth much more, or a property, or there may be that there was cash lying in the mattresses. There's, that there was way more there. And these are some of the issues that come up because there's not a lot of checks and balances. Usually, there can be in probate pre-death transfers that are challenged also, and those situations are generally where someone in the name of the decedent, the person who's died, did something, sold off some assets or entered into some agreements, and usually there's allegations that that was to the benefit of that person or someone closely related, and those are types of challenges that can come out after a person dies, when all of a sudden they're not the owner of the farm anymore, or someone else, is the contract purchaser with an option to buy the farm at, 25% under appraised value because they gave a note previously. Generally, if there is any valid claims asserted that involve an estate, the estate's expenses to prosecute or defend are generally borne by the estate, and so that just dissipates the estate. If another party validly prosecutes against an estate, they can also get their costs from the estate if they successfully challenge the will or any of the components of it. And that's very different in most aspects of our judicial system. Each side pays, even if you prevail or win, unless there's like a fraud component or unless by contract you agree to, if something's challenged, like in a lease, if you have to go and collect and enforce your right, you can get attorney's fees. In estate matters, many times there can be an application for defense costs and legal costs against the estate from both sides, and that's another reason it can deplete the assets. Following up, after you do your estate planning, where do you have your documents? And many times you have to, if you have advanced medical directives, don't you want your doctors to have that? Don't you want the people who are going to make the decisions for you have them? Same with power of attorney. The original wills, many attorneys will keep an original in a safe. They will give it to you. You need to give letters of instructions and let people know where your will is, where your life insurance policies are, what you're doing in terms of, letters of instructions could also say where you want your remains and what types of burial instructions. Usually if you have a safety deposit box, and this is just a protection, you can move certain things, but otherwise you have to have the Inheritance Tax Bureau present so that they're watching that people aren't just removing things and not reporting them. Bob, I'll just have to emphasize this. Bob had gone over, when do you want to update your documents, your wills? You want to do it when you have different life changes or economic or personal circumstances change. Beneficiaries, your own control is always there, but you want to do it if you look at the functionaries. Who's going to be the guardian? Who's going to be? Is there a need for a trust if the beneficiaries are of age of majority or the age that you want to distribute, which may be different? You may want to hold out and say, I'm going to distribute a certain amount at 25 rather than 18. But you want to look at those things because it really doesn't help if the people who you're entrusting to take care of your wishes aren't around or can't function. If they're your parents and they're frail at this point. There may be opportunities and requirements or desirable to change when there's changes in the laws. I know in the end of 2012 there was a lot of changes coming around, thoughts of it, and all the estate attorneys were bombarded with people wanting to make changes in their plans. You may get an attorney, I wouldn't call it a solicitation, but they should be in constant communication with you, even after you've done your plan, to say, hey, you might want to think about this. This is a new law or regulation that came out. I'm thinking of you, and it may be time to revisit it. 2 documents I want to go over. Everyone should have them, and non-estate planning and elder law attorneys will prepare them. They're fairly basic, but they're so critical, and I'll go over them. One is a power of attorney, and the other is the advanced medical directives, and it's really about continuing the decision-making process like I was talking about before, continuity of legal authority. If you're in a car accident, it could happen today, and you're not able to make your decisions. Advanced medical directive is just for your medical care and decisions, and you have to actually give them to the designees. A lot of healthcare facilities, if you come in and don't have one, they will have you do one there. But just think of it, at that point you're in a state where you really don't want to think something bad's going to happen. You don't really have a discourse with the nurse or the administrative person that comes in, and it's not the most opportune. It's not an expensive proposition. Attorneys generally, if maybe $100, $200 to prepare both documents. But they are formed, but they give everyone an opportunity to discuss the issues and how they'd like to be treated. What is the command of, that they've liked. Things also when I say about choosing the person, and this is a personal, it's not, you want to choose someone who's going to honor your wishes and respect your desires and can live with it. And I think that's an important factor that some people, if they're going to wrestle with the decision and be tormented by it, maybe they're not the right person. And I also think that sometimes you, as the person who is giving the instruction, when you give it to them, say, and you have a little conversation, I don't want to be on a respirator. I don't, I'll recite from my mother's passing. My dad was broken up and my mother was having trouble breathing, and they said, we're going to help her to breathe. That's how they described it to him. I stepped in and I said, Dad, that means a respirator. Mom doesn't want that. So it's also, you have to have someone who's astute and really understands and won't get broken up over the fact. And really, I think the medical community has come a long way in terms of honoring the DNRs and certainly some other aspects, but it has to be clearly articulated, and that's what this document does.
I just want to let everybody know, we said 4 o'clock to leave, but I hate to shut down important information. We're going to go a little bit over, but if you have an appointment, certainly you can go when you want.
Okay. Power of attorney. Why do you need this? Everyone needs one. If something happens and you're, incapacitated, it's who's going to step in, and it's not just for medical decisions. It may be who's going to pay your mortgage, who's going to do anything. Now, there's all types of power of attorney. There can be springing. It could happen if you're incapacitated. It can be a durable and a general power of attorney to help an elderly relative because you're going to manage their affairs. What they do is they avoid the need, to a certain extent, of conservatorships, which is a voluntary legal process, but it's more formal. And there's also a guardianship, which I've touched upon, which is a fairly stringent level of interplay between both the person seeking the guardianship as well as the court to make sure that the rights of the person should be taken away. You can generally do everything that the person can do in a legal capacity. I did have a gentleman come yesterday, and he asked if a person who is a power of attorney can change a person's will, and that they can't do. And the person would have to have the capacity to grant, so usually when you go to an attorney to have a POA executed, they're going to make sure that the person has the capacity to make this. You don't want to wait too long, and unfortunately that happens sometimes where people go to a practitioner and they say, I don't feel comfortable giving you the power, the person who's brought mom or dad in, because I don't think they have the capacity to make that determination now. You've lost, there was a window and you've lost it. If it is to survive someone's disability or incapacitation, it has to say that it's durable. You have to have gifting language if you want to avoid some tax consequences. There's a specific statute in New Jersey, and they deal with language for specific types of, banking language. And generally, believe it or not, the POA could be a 10-page document if it's giving that many powers and you want to have the specificity. But it's a form document. They're not drafting it up every time they're doing it. Revocation. The person who gives it can take it away, but what you want to do is make sure you physically get it back. And I have asked for those back from other, POAs, and sometimes it's just you're refreshing it because you think there might have been one out there that this person gave and they're not really remembering, so we're refreshing the one that we did 10 years ago to make sure we can ascertain that it's the most recent one. But you do want to get it back, because you don't want to have two outstanding, so then two people are POAs, or seemingly POAs, although the latter one would prevail. Advanced medical directives. This is your healthcare proxy. You can go through, if you're married and you divorce, divorce revokes it from the spouse. There are some limitations if you're in a facility who can be the proxy. They don't want someone in the facility who's working there to really be your health proxy. There's usually a triggering event and a triggering determination of when the person can make the the determinations, and you could have that relative to your healthcare decisions. And again, you want to make the idea that the person knows when they're going to be in charge. It may be if you're in a coma. It may be not just because I'm in the hospital for a broken leg, someone doesn't take control of my medical decisions. Your document will say what's the triggering characteristic or condition that empowers the proxy. If you're not clearly incapacitated, usually, they want a letter of the attending physician, someone like that, to ensure that, if they're the one being asked to make, if you're a family member and you're being asked to make a decision, you want to know that you're doing so rightfully. And that's it. If there's any other questions.